Welcome to a special joint edition of the International Law Chats and Just Security podcasts. I'm Megan Corrarino, Managing Editor of Just Security, here with Chiara Giorgetti, Walter W. and Maria Teresa Reguera Research Scholar in International Law and Professor of Law at University of Richmond School of Law. I'm also here with Milena Sterio, the James A. Thomas Distinguished Professor of Law at Cleveland State University College of Law, and with Rebecca Hamilton, Professor of Law at American University Washington College of Law. Chiara and Milena are two of the three co-hosts of International Law Chats, ILC for short, a podcast from the American branch of the International Law Association, or ABILA. New episodes of ILC are published the first Monday of every month. Chiara serves as the Vice President of ABILA, and Milena as Co-Director of Studies and a member of ABILA's Board of Directors. Beck serves as a Just Security Executive Editor, and all are widely recognized experts in international law. We're here today at the end of ABILA's International Law Weekend, where the theme was Crisis as Catalyst in International Law. I'm sure we'll get into more detail in the discussion, but to provide a brief flavor of the weekend, Chiara spoke on a panel entitled A New Role for the ICJ, which looked at some of the different ways the court is involved in dispute resolution and the development of international law. Milena moderated a panel, Crimes Against the Environment, Nature, and Biodiversity, looking at how the international legal order does and doesn't capture environmental crimes, and where emerging legal tools may help fill the gaps. And Beck and I participated in Narrative Strategies and International Environmental Law, looking at the nexus between the development of environmental law and public communication. Other speakers across the 2.5 days covered topics including human rights and humanitarian law, the role of the United Nations and other international organizations, legal frameworks like the World Trading System, international arbitration, and more. Milena, Chiara, Beck, welcome, and thank you for being here. To begin, I'd like to invite you each to reflect on the theme of the weekend, Crisis as Catalyst in International Law. There's a hopeful idea embedded in that framing, to borrow from some of the language of the weekend's program, that crises, quote, compel actors to confront the limitations of extant legal systems and create opportunities to reevaluate and reconstruct international legal norms. In practice, among the panels I attended, views were mixed, with some people articulating paths to turn crisis into reform, and some acknowledging that, in their particular practice area, this is a very difficult moment without a clear path forward. How do you see this tension? What factors might be at play in determining when crisis can strengthen international law, as opposed to merely undermining it? And Chiara, shall we start with you?
Absolutely. Well, let me first of all thank you, Megan, and the entire Just Security and ABILA teams. It's really a lot of fun to be doing this together. I'm glad to reflect on the theme of the weekend because I found the idea of crisis as catalyst very thought-provoking, and it really permeates, as you said, in the discussions in the panels that I attended. There is certainly a tension between seeing crisis as destructive of specific norms or legal system, or really more generally, and crises are constructive, maybe an opportunity to build something new. To me, I can see how this critical, really an inflection point, crisis can lead to three different results. One is an impetus for reform. In the keynote with Matt Kinnear, Lucinda Lowe, and moderated by Melly Darkson on investment state dispute settlement reform, that was a very good point. There was an identification of a backlash or some criticism of the system, of the ISDS system, and then an impetus for reform with the answer to Working Group 3 and the exit rules reform, really how to address some of the questions that were some of the issues that created the crisis or the concerns. Second, and I think is also quite interesting, as a way to identify the causes of the crisis. And this was one of the points that was made in a panel that I participated called the UN at 80. And I think the point was made that we always say that veto is one of the issue, a very important issue for the United Nations, and the idea of the Security Council inability to perform its role. But what I think that the panelists were saying there is that it's not only the veto, but the entire role of the P5 in the charter that should be addressed. So the fact, for example, of elections or the issues of the amendments, So really identify the causes of the crisis to understand maybe how to resolve it. And then third, as a way to identify ways to overcome or maybe walk around the crisis. For example, the panel that I participated in was focused on the new role of the International Court of Justice. And here it's quite interesting because the International Court of Justice has expanded its role, both in terms of advisory opinions on very topical and timely international legal issues, of course, climate change, but also more recently, also humanitarian access, and also in contentious cases, both in terms of numbers, but also on the issues, on the matters that the ICJ has been asked to resolve. For example, issues pertaining to the use of force, but also on the kind of obligations, erga omnes partes obligation or issues of jus cogens. And the idea of high level of participation, right? Why all these countries and state members participate and use the International Court of Justice more, and also in advisory opinions. So I think this is interesting, these three ways. And in some, just as a catalyst can spark a reaction or an inhibitor can slow it, the response to a crisis in international law may vary, both in pace and form. Each path transforms the system in its own way. I think it is important to recognize these differences and transformation, and also look for maybe unexpected or different reactions on how to address this crisis.
Great, thank you. Back over to you.
Thanks. It's so great to be in conversation with all of you. So, I mean, I should preface all my remarks by saying I'm inherently an optimist. But it is absolutely true that we see sort of forward movement in international law through moments of crisis. And whether that's a good thing or a bad thing, I think we can have a conversation about. But, we get new custom when old custom is broken. We get treaties when states hit the point where there's really no alternative but to come together in order to try to address a problem. And the bar for that is usually pretty high. It is also true, though, when we look at sort of the international order over the past century, we see that system-wide change happening only after a world war, right? World War I, League of Nations, World War II, UN Charter. So, and let us hope we don't need to get to World War III level of destruction before we address the problems that are there with the current system. And I think, that my only pushback on the framing of the weekend is crisis implies something new. There are degrees of this which is new, but for a lot of states and for, I think more importantly, many, many human beings within those states, this system hasn't been working for them for a very long time, in some cases forever, right? And so international law from their perspective has always been in crisis. What is different, I think, in this moment is that up until now, you have had the hegemonic power in the system, at least seeking to uphold it. The panel that I attended on crimes against humanity, Tom Dannenbaum laid this out beautifully in terms of what it means for 3 out of the 5 members of the P5, but the US in particular, to be undermining such a core principle as Article 2.4 of the Charter in such a brazen fashion. This sort of imperviousness to shame and a total disregard for even attempting to justify actions when we think about the strikes that are happening on sea vessels outside, in the territory of foreign states or in international waters, not even an interest in engaging in the question of how this might be justified with respect to international law. And so if you don't have even those hegemonic powers within the system interested in sustaining the current order, that is a significant shift, right? And so, the interesting question, and one of the things that I loved about the weekend, because there was the spark of promise at different moments, is can everyone who has been pointing out the flaws within the current system, pointing out the mismatch between the P5 that we have and the world as it is it possible to seize this moment to build a new system that actually does better? Or are we going to see a collapse of the old while replicating those power dynamics just in a new form?
Great. Thank you, Beck. Milena?
It's also such a pleasure to be here. So thank you so much for putting all of this together. So first of all, let me start by saying that ultimately I agree with everything that Chiara and Beck have already stated, but let me just add a few more points. Like Beck Hamilton, I'm also an optimist, and I do believe that each crisis also presents an opportunity to challenge international law in a constructive way, but also to push for the development of new norms or to push for the tweaking of the existing ones if that's necessary. And so one issue that was discussed at several panels that Chiara already mentioned was the Security Council's ongoing paralysis and the possibility of either imposing legal limits on the use of the veto or the possibility of turning to the General Assembly under the Uniting for Peace mechanism or in other constructive ways. Another issue that's a crisis that was discussed at multiple panels was the environment, the ongoing issues related to climate change, the rising of sea levels, the melting of glaciers, etc. All tremendous crises. But as was discussed at multiple panels during International Law Weekend, we are witnessing an incredible moment where various civil and criminal law mechanisms and tools are being considered and developed to address the environmental crisis. And we may be witnessing a coming together of sorts where international law becomes incredibly useful, coming from different jurisdictions, different courts, different sources of law, different actions by various international organizations, bodies, state and non-state actors. And so as Winston Churchill famously stated, never let a good crisis go to waste. I do think that the ongoing crisis presents a tremendous opportunity to appropriately respond using all the various tools that we have within the international law toolkit, but also to attempt to reform, redefine, reinterpret international law if that is necessary.
Great, thank you. Milena, a phrase that you used was people coming together, and this was, of course, a gathering of international lawyers. There was an undercurrent throughout, it seemed like, of the question, what is my role in the world at the moment? And a number of the panels dealt with that explicitly or implicitly, looking at the responsibilities of law firms, of civil society, of international organizations, of lawyers themselves. There were also many law students and impressive emerging scholars present who must be thinking about what the role of an international lawyer is going to look like a decade or more from now. What do you all see as the role of international lawyers today? And as professors, what sort of advice would you give to people who are starting or thinking about starting a career in international law right now? And shall we go in reverse order? And Milena, start with you.
Sure. So let me actually address your latter point or question about younger people pursuing careers in international law. I do think that because we're in a time of crisis, especially here in the United States, some younger folks may be discouraged from pursuing a career in international law. But I would seriously urge them to reconsider this decision. As was mentioned before, there have already been crises in international law. This is not the first one. And I do believe that international law has always found a way to emerge stronger and better. And this goes to definitely my nature as an optimist. But I do believe in international law, and I do believe that international law will be able to, sort of overcome in some ways the current ongoing crises. And it is actually during or immediately after times of crises that we often witness the development of new international law norms. During crises, though, is when we need new voices, student voices, activism in international law. This is precisely when we need concentrated, significant efforts and action to support international law, to raise awareness about international law, to say international law truly matters. So instead of deciding not to pursue a career in international law, for all of our younger listeners, I think you should go for it. I think we increasingly need international law in the future and currently to address ongoing crises such as the environment, such as the misuse of force, to counter authoritarianism, to counter regimes which tend to misuse or ignore international law. But international law cannot practice itself. We actually need lawyers and people to use it, to apply, to continue to proclaim its value. And so I would say, don't discount international law. Your voices will continue to be valuable. We need you. We need those new voices. Come join us in this field of international law.
Great. Thank you. Beth?
No surprise, I'm going to double down on the same mantra. I'm telling students, this is the time. Learn, study the system, figure out for yourself what works, what doesn't, who it's been working for, why it has been working for them and not others, because there's a reckoning that is coming with the system within the lifetime of your careers. And so you want to be positioned to be the architects for what the future of international law is going to look like. And the really pressing challenges that are facing us in the 21st century, when we think about the environment, when we think about mass migration, when we think about big tech, all of these are issues that cannot be dealt with just with domestic law alone. Like it is literally going to be impossible for that to be the model to pursue. So we're going to need international law in some form. To the extent that the form that it is in needs shifts to happen for it to work for more people, then if you're a student of international law right now, it is the perfect time to set yourself up to be an architect for change in that system. So that is my pitch to the students listening. Really, there's not been a better time. For those of us that are in it, I agree. We need to uphold the principles that are working, and some of this is just coming back to really, really basics in this moment. Respect for the rule of law. The rule of law saves lives, period. And it's something that too often we don't think to champion when it's sort of just been running more or less for many people. I would say, again, there have been plenty of people who have been saying this has not been happening, and there's been a cost. But particularly in, we're having this conversation in a US domestic context, it's exactly when politicians are giving short shrift to these principles that there's a role for lawyers to stand up. The other thing that I think is really important in this moment, and this goes back to something that Chiara said at the beginning, is accurate problem diagnosis. Okay, so, and I'm just thinking of a piece I wrote on criminalizing ecocide. We have the climate emergency as a key problem. We want international law to help in a multi-pronged approach to addressing it. But I'm reluctant to say we just apply international law as it has currently and traditionally been exercised to the problem without first going through a process of reflection to recognize international law's role perhaps in helping to create the problem in the first place. And when I'm talking about the environment, I'm talking about international law's sort of traditional bifurcation of the relationship between humans and nature, something that tons of indigenous knowledge, as well as scientists today, are telling us is just not an accurate reflection of the world. It's just something that a sort of approach has developed in international law over time to accept that. So if we're going to be addressing a crisis, let's make sure that the tools of international law that we're using in order to address it are really fit for purpose. But as to students, get in there now, study the system, help us figure out how to do it better.
Great. Thank you. Chiara?
Thank you very much. So I join my colleagues Beck and Milena to say to the students, absolutely, the role of international lawyers have never been more important. It's really more important than ever. And indeed, I was talking recently to a student, and I was asked, by them who, you know, whether it was the right time to enter international environmental law. And I told them, absolutely, this is the time. This is the right time to study international law and to participate and understand the system. With an advice also. One is, you know, once you pursue a career in international law, I think it's very important always to be flexible. The different paths to reach the same destination, and in terms of, I think international law might be more different than others. And so I think it's important to be open to new possibilities for students in terms of how to practice international law. On a more practical way, and maybe I can put here my practitioner hat on, I think the moment of crisis may result in very practical needs of international lawyers. For example, I can see more litigation ensuing from some of the violations that are occurring now, whether it is tariffs, for example, or other international economic issues, or climate change. Very clearly, the International Court of Justice, in its recent advisory opinion, said that, you know, the countries, member states have obligations. And when this was reported by the BBC, for example, it said that the headline was, the ICJ opens up for more litigation. So there might be, on a practical way, more need for international lawyers for litigation, but also more need for lawyers who know about the rules of the game and, for example, can advise their own countries on the use of force, the rules applicable to the use of force. Right, this is very important, and advise their respective states. And then on a point of others that Beck was making on the kind of the role of those of us who already are international lawyers and the point of the rule of law, I think it's very important that we continue to maintain and know what the rules are and ensure that the rule of law is upheld, and especially for those of us that come from maybe smaller states, smaller countries that don't have the veto power, not part of the P5. I think the system has to work for everybody, and I think it is a very, very important moment for international lawyers to be active and make sure that the system is that the rules that exist are known and then, of course, applied.
Great. Well, first of all, thank you all for those sort of very inspiring words, but words that are also grounded in sort of the complicated nature of the moment right now. I think for me, that was very, very powerful and helpful to hear. And I'm sure that's true for many of our listeners as well. Chiara, to one of the last things that you mentioned, it was about sort of transitioning from the general to the specific. And I think that ties into another question that I have been thinking about this weekend, which is that people are going to want to come away from the weekend looking to synthesize these themes into action. And there was a lot of discussion at what one might call the more philosophical or long-term level of how international institutions can respond effectively to a sense that the world is at a crossroads. And at the same time, there were a number of very practical and granular discussions. You know, how might a seabed mining legal regime be created? How can disputes be resolved under different arbitration frameworks? And I'd be curious to ask to each of you, were there any places where you heard a particular concrete mechanism or approach articulated that you thought, this is something that might help bridge that gap between the aspirational goals of international law and the practical implementation in the world as it is today? Beck, do you want to start?
Sure. So, you know, a few things. So the most obvious one that comes to mind, and this has, you know, this has been years and years and years of dedication to get to this point, but the conversations around the Crimes Against Humanity Treaty. It feels like that is finally sort of on the cusp of coming to life after so much work and conversation. And I think that is going to make a big difference in a lot of areas. And the other one was, as Chiara mentioned, that the advisory opinion from the ICJ on climate really was the court saying it is opening the door to cases being brought. And I had just come off a previous conference in Aotearoa, New Zealand, on adaptation futures with a whole lot of Pacific youth who have been such leaders in this space, and hearing how they're thinking about how to translate that advisory opinion, although formally not binding, extremely powerful, into the advocacy that they're doing and the conversations around understanding. And I think this is something international lawyers have a much better sense of than certainly US domestic lawyers, that getting a good court decision is the start of a process, not the end of a process. And so all the creative strategizing about how to turn some of that extraordinary and really excellent language that the ICJ has been coming up with in the climate cases, but also, we look forward to the advisory opinion that will come out in relation to what's happening in Gaza, as well as last week's decision, how to take that language and put it into effectively advocacy, into the political space, into the diplomatic space, and really translate it into meaningful change for people on the ground.
Great. Thank you. Milena?
Yeah, so there were lots of very, very interesting discussions across panels, and I think you framed your question perfectly, that on the one hand, there were discussions that were more general or philosophical, and I think most of those questions had to do with, is this time of crisis surmountable? Will international law survive? And then there were also many other more practical, and as you said, granular discussions. And so on the latter point about those more granular discussions, as I mentioned earlier, there were multiple panels that addressed the issue of the use of force, whether it be within the context of the Ukraine or Gaza wars, but also there was a hot topic panel that had to do with the more recent U.S. strikes against allegedly narco-trafficking boats. And so lots of discussions on use of force issues, both at the general level, but also at the more granular level, with ideas ranging from, again, the use of the vetoes, should there be legal limits on the use of the vetoes, but also more granular ideas about how to resort to the General Assembly or perhaps other mechanisms that were traditionally not empowered with handling those use of force issues in the wake of the ongoing Security Council paralysis. The other issue that I already brought up, but I wanted to emphasize again, was the issue of the environment and more granular ideas about what can be done to now implement the advisory opinion. As Beck just very correctly mentioned, the court decision is really just a starting point in this context as well. So there were discussions about continuing to use what I would call parallel proceedings at various tribunals, both on the civil side and the criminal side, to essentially force state and non-state actors into compliance with this idea that they need to do more to protect the environment. Specific ideas about, for example, using the ongoing treaty negotiations in the context of the Crimes Against Humanity draft treaty. Those treaty negotiations have been taking place over the past several years. And so continuing to use those treaty negotiations to insert more robust provisions into the draft treaty that had to do with protecting the environment, that have to do with, sort of establishing that there is a crime against humanity that has to do with harming the environment. Also using some other treaty and soft law instruments, such as, for example, the Palermo Protocol, which has to do with transnational crimes, to also include in their provisions that have to do with environmental protection. And then last, I would say that there was a lot of discussion, both at the general level, but also at the more granular level, about how do we use all the different tools that we have within international law to address current concerns, the current crises that has to do with the environment, has to do with the use of force, has to do with the rise of authoritarian regimes, has to do with regimes that again, just abuse or ignore international law. So how do we go about using all the various instruments that we already have at our disposal? How do we go about reforming those instruments? And again, how do we use international law in a constructive and positive way?
Great. Thank you. Chiara?
Thank you very much. I really love this question. It's a very interesting one because, of course, we go to this conference to discuss the theory, but at the end, we really want practical things. And indeed, I heard a lot of very practical discussions on how to address the problems that we have identified, and I'm kind of a practical person myself, so I really liked all of these. I would like to point out a couple. One is, again, as I mentioned before on the keynote on ISDS, and this is quite interesting because in Working Group 3 reform issues on ISDS, the ancestral reform process, for example, here there are discussions about the establishment of a new court, like a new permanent court on investment arbitration. And that will be quite a substantial reform, a very practical way to address issues. The other one, and this has been mentioned already, coming from the advisory opinion on climate change. Now, this is not only litigation, but in a very more practical way, there is now a draft General Assembly resolution that's been circulated. I haven't seen it, but I can't wait to see it. And I think it's been drafted by Vanuatu at the moment on how to implement the advisory opinion, very specific steps on how to implement it. Other issues, other practical discussions maybe have been reminded of. On the Security Council, for example, the veto initiative that was very much prompted by Liechtenstein, that requires the P5, when they use the veto, to come to the General Assembly and essentially explain why they used it. Now, this is again an explanation on why and a way to address the issue of the veto. And also has others have mentioned, as Milena mentioned also on the crimes against humanity, amendments. Now there's a process of treaty negotiations, and there's specific amendments that can be discussed and can be proposed to the treaty negotiators. And one last thing, one important thing, I think. Now the ILW, the International Law Weekend, is organized to coincide with International Law Week. And International Law Week is the week where all the legal advisors from different capitals come to the United Nations and discuss issues. And there were several legal advisors that came to International Law Weekend and engaged in the discussions. I think that will have a very practical effect in translating the discussions that we've had into their discussions in a very practical way on the sixth committee this week. And can ignite, like in a sparkle, just to continue maybe with a chemistry metaphor, new ideas and how to implement these ideas in a very practical way.
Great. Thank you. Thank you all for those responses. And this has been such a rich discussion. Before we wrap up, I just wanted to kind of throw one last question out, which is beyond what we've already discussed. Was there any one moment that stood out to you as memorable from the weekend, or anything else that you're going to take away from it? Milena, shall we start with you?
Well, what was really, I don't want to say memorable, but what was great to see was that every single conference room was filled to capacity. I ended up standing during multiple panels because I would get there like too late, sort of a few minutes after the panel has started. And literally the room would be filled to capacity with people standing in the back, standing on the side. Literally there were students standing in the hallway trying to sort of, peek in and hear in. And I think that's that's very powerful, because it speaks to the fact that even with the fact that we have this ongoing crisis, students, everybody interested in international law who happen to be in New York City still believe in international law. If they didn't believe in international law, I don't think that they would be attending all these panels in International Law Weekend, particularly when it involved standing for about 90 minutes in a super, full and pretty hot room, right? So that speaks to the power of international law, and it speaks to this interest that we all still have in international law. So I think for all of us here, it goes back to my prior point about students, younger professionals, don't give up on international law, continue to practice international law. We need you. The best we can do is to, again, continue to use all the tools that we have at our disposal and continue to try to improve and enforce international law.
Great. Thank you. Beth, over to you.
And I would absolutely echo that. I think, part of the joy of the weekend was just the sense of, everyone gathering together and highly, highly engaged. I think it's clear for people for whom, even those people that perhaps international law has been a theoretical exercise in the past, the stakes have become much more concrete, even for those people. There's a sense of urgency and necessity. And so that sense of coming together to try to figure out how to handle this moment was kind of the nourishment that my soul needed as much as anything else. And the only other thing, and Megan, this sort of comes off our panel because we were talking about public narratives, public-facing narratives. And as much as it's wonderful to gather international lawyers and students of international law and have those conversations ourselves, I truly believe that if international law is going to thrive, it also involves bringing in a broader group and the public at large, and thinking about how those public narratives around why international law actually matters to individuals in their day-to-day lives is one of the many pressing and important tasks for us to be working on in the current period.
Yeah, very much agree. Chiara?
Thank you. Thank you very much. I agree with what was said before. What I thought was very interesting is as soon as you enter into the Fordham building, which is a beautiful building, by the way, you could really feel the energy, right? Energized community. And we could see the community of international lawyers. And I felt a very strong sense of community, but also of service. And I thought that was very interesting. We were all there together to discuss international law, to address the crisis, but also to find solution. And I'm reminded, of course, of Oscar Schaster's the idea of the invisible college of law, the description of this informal but influential network of international lawyers that include all of us, include scholars, governmental advisors, legal practitioners, and of course, students who share these ideas about international law and the process and the shape, the development of international law. And so I think this is very impactful. I think it's quite interesting. You can see the impact some of them we mentioned already, the negotiation on the Crimes Against Humanity Treaty, on climate change, obligation of Israel, and the advisory opinion that came out just last week on the obligation of Israel and the advisory opinion. But of course we want to, and I think this is another interesting point, we want this kind of invisible college of law to continue to be diverse and inclusive. And I thought also that was very interesting to see that the keynotes were all female keynote speakers on Friday, and I see that we're all also female on the podcast. So I think this is also very interesting, and see how this community, which again is an energized community, which I think is very kind of service oriented and the want to try and make things better, can also continue to be diverse and continue to be inclusive.
Great. Well, thank you all so much. It was such a pleasure to have this conversation with you all and to get the chance to participate jointly across our respective podcasts. This was a special joint episode of the International Law Chats and Just Security podcasts. I'm Megan Corrarino and was joined with many thanks by Professors Beck Hamilton, Milena Sterio, and Chiara Giorgetti. This episode was produced by Freya Doughty Wagner on behalf of International Law Chats, with help from Maya Neer and Pooja Shah at Just Security. Just Security is hosting a series of written articles in connection with International Law Weekend, with more forthcoming over the coming days and weeks. You can read these and other expert analyses of cutting-edge international law issues, including by each of today's fantastic podcast participants, on our website. If you enjoyed this episode, please give both podcasts a 5-star rating on Apple Podcasts or wherever you listen.